and Steve will go into this in far greater detail, is actually historic. It's a historic moment for Happy, for the rights of non-human animals in general, because for the first time, the case is being heard by the highest court of English-speaking jurisdiction. In our case, being
Oh,
Uh-oh, is
uh-oh.
Liddy having a problem here? Let's see.
I think we're having a little bit of a technical
If
problem.
we are, or Liddy is.
Or Liddy is. I think.
Okay, well, while she's working to get on, then I'll just keep talking. And
Yeah, please do.
so I will let her talk about the arguments in the brief, but I'll begin to talk about some of the other things. First of all, why it's important and why it is historic. So that is something that she mentioned briefly. It's important because it's actually the first time that any high court anywhere in the world has ever said that they wanted to talk about whether or not any non-human animal should ever have a legal right. And it's also the first time that an English-speaking court anywhere has ever wanted to make a determination as to whether the common law will allow a non-human animal right. So that's those are huge things. You know, even we in the Non-Human Rights Project, you know, have been working on this now for many years. You know, well over a decade, and have been filing lawsuits. You know, for 8 years, and this is still the first time that we have ever been able to do this. In fact, I'll tell you a little bit what occurred, which is that I believe we filed 8 lawsuits in New York, and we filed 2 in Connecticut, but we filed 8 lawsuits in New York on behalf of chimpanzees, on behalf of one elephant. So we filed these cases, and the purpose of them all was to get the arguments that we're making to the highest court in New York, which is the Court of Appeals. And so here it's now 8 years, and we were really unable ever to do that. We would go into a trial court, which in strangely enough in New York is called the Supreme Court. So we would litigate Supreme Court cases, and then we would always expect to lose, and we would lose. And the reason we would lose is nobody in New York had ever argued that a non-human animal, you know, can be a person, which means not they can be a person, and it means that they can have some kind of a right. So we would do that, and then after we would lose the case for whatever reasons, we would then have to move to the intermediate appellate courts in the state of New York. So I think there's more than 200 lower courts or Supreme Courts in the state of New York, and then it can go up to 4 intermediate appellate courts. And so you'd have the first, second, third, and fourth departments, and the first department is in Manhattan, the second one is Long Island, the third one is in Albany, and the fourth one is in Niagara Falls. So they're very different. So we would bring those sorts of cases into the intermediate appellate courts and try to win, although we knew that it was unlikely we would be able to do so. The interesting things about it is that we indeed did lose in front of all 4 intermediate appellate courts, but they would never agree on it. They would all have a different reason for having us lose, which we found was, you know, very interesting and rather strange, that there seemed to be judges, you know, in each of these places, and a majority of them, or mostly none of them, wanted us to win, but none of them wanted to give the reasons really of why the other court had ruled against us. So we understood that was strange, but it was also something that we expected. So what we would then do is that we would ask the highest court in the state of New York, which is the Court of Appeals of New York. We'd say, would you please hear our case? Now, when you go in front of an intermediate appellate court, they have to take your case. Although that's one of the errors that one of the intermediate courts did, is that they actually didn't want to take our case, and it turned out that was illegal. But the other ones would have different ideas, and nobody would ever say they couldn't take a case. So then every time we lost, and except for that first time when they made a mistake as to whether we could appeal or not, what we then would do is ask the Court of Appeals that they would please hear the case. Could we wanted our chimpanzee or elephant to please be seen as entities who were persons in New York and who had rights. And what would happen, and which wasn't completely unexpected, what would happen coming out of the Court of Appeals, which itself always says that there are thousands of people, thousands of entities who want us to hear their cases every year, but we only take 5% of the cases. So that means it's only 1 out of every 20 cases that someone who ever wanted to go to the Court of Appeals to take the case. So they just simply would not. We would go up, and then 2 times before 2018, they simply said denied. That was it, denied. And in fact, sometimes they'd put us in a list of more than 1,000 people at one time, and we would look through them, and we found 1, we found 2, and we knew that we had been denied as more than 1,000 other people had done so too. Then what happened in 2018, we again lost, and this time was the first time that we had lost by a court who basically said, well, the reasons you can't get rights is because you're not a human being, and the only entity who can get rights is a human being. Of course, that was the thing that we had been working on for a long time. The same thing then happened. It came back, and the court refused to take our case. It simply said denied. However, this time something different happened. There was a judge on there named Eugene Fahey, and he actually wrote many things, but one of the things he was writing was the fact that he had indeed voted against us those first 2 times. And now in this third time, the question was he going to then, was he going to rule in our favor? Had he made a mistake? And he was very clear in his decision that he thought that the court should take the case, and he thought we had a pretty good chance of winning. Let me tell you a little bit about that. I'll read, in fact, just a few sentences here and there. This is Judge Fahey. For example, one of the most interesting things he wrote was simply in his last paragraph, where he said, I've struggled with whether it's the right decision to have not heard the Non-Human Rights Project twice. So this is the 3rd time. He says, I have struggled with whether this was the right decision. Like, should he been part of it by saying no? Then he says, although I concur in the court's decision to deny leave to appeal now, I continue to question whether the court was right to deny leave in the first instance. Now we're in the 3rd. Then he says this: the issue of whether a non-human animal has a fundamental right to liberty protected by the writ of habeas corpus, which is what our cases are all about. He said it is profound and it's far-reaching. It speaks to our relationship with all the life around us, ultimately when we will not be able to ignore it. And while it may be arguable that a chimpanzee is not a person, there's no doubt that it is not merely a thing. Now, there's something unusual about that sentence, and also it's exceedingly important. Ever since Roman times, and certainly in Western law, you're either one or the other. You're either a person or you're a thing. And if you are a person, that means that you have the entity for 1 or a million, 1 or more legal rights. And if you're a thing, it means you don't have the capacity for any kind of a legal right. And that had been an issue that had gone on for more than 2,000 years. And so now you oftentimes ran into courts who simply didn't like that. But he was the one for the first time who said, when you look at a non-human animal, you should look at the possibility of them being a person, which means if they're right, then they're persons, then they have rights. But if they are if there are things that then they don't. Now, that remember at the end it said it may be arguable that a chimpanzee is not a person. Notice he didn't say it may be arguable that a chimpanzee is a person. He's kind of believing that a chimpanzee is a person, because he's saying while it may be arguable that a chimpanzee is not a person, there is no doubt that it is not merely a thing. This is the first person who the Non-Human Rights Project, knows at all that has ever said that there's no doubt that a non-human animal is indeed a person and not a thing. So one of the things that we began to want to do immediately is to begin the process of filing our next case that we hoped we would be able to win, but that if we didn't win, then how were we going to deal with and how successful might we be in getting the case up to the New York Court of Appeals? So that's what we did. However, one of the first things we did was to look to see whether or not there was another chimpanzee who we might want to bring suit, because the Judge Fahey's case had been about a chimpanzee. It turned out that there were no more chimpanzees in the state of New York who we could find. So therefore, we've never been able to file another lawsuit in New York on behalf of a chimpanzee. We just don't know of any that are still in New York. If we did, then we might do that. So, but we had been looking at another species, which are elephants, for many, many years. In fact, at the very beginning, when we made a decision, we talked about the first thing that we decided to do was to file a lawsuit on behalf of an elephant. And then we ultimately, at the last minute, said, no, it won't be an elephant the first time, it'll be a chimpanzee. And so that's exactly what we did. But now now there were no chimpanzees left who we could sue, but there were elephants. And so we had begun to look into which elephants we wanted. And the one that we chose was Happy, who's an elephant in the Bronx Zoo. Let's see if, hold on a second. If Liddy's back, I'll let her then take the
yes,
case from.
I am back, Steve, and I've been listening very attentively.
Oh,
to
good.
you. Yes. So do you want me to take it from there?
Well, yes. Why don't you start talking about what happened to
Sure.
Happy, and then how the brief worked, and then I can start talking about other things as well.
Sure. Excellent. And please, whenever, feel free to add whatever you would like. But what I would to add what Steve was saying, just a few things. First of all, in terms of the history of our chimpanzee cases, as Steve was explaining, we always expected to lose. And our goal was, as we have done, to get to the Court of Appeals. But what I always like to kind of explain in those terms is that while it may appear that we have lost and then we have to appeal, in my opinion, we actually won, because nobody ever expected that any court would grant a non-human animal a writ of habeas corpus, which is what we successfully obtained on behalf of Happy just recently, and on behalf of 2 chimpanzees at Stony Brook who are being imprisoned for research purposes, Hercules and Leo. And it was only because we were able to obtain those writs of habeas corpus, or in New York, they're called also orders to show cause. It was only because we were able to get those that we actually had hearings, both for Hercules and Leo, in front of a New York, as they call the Supreme Court, a New York trial court in Manhattan, and also on behalf of Happy. And it was through those decisions as well. And, I'll talk briefly about the decision that we got from Justice Stewart on behalf of Happy, that we also got extraordinary language, particularly with respect to Happy, and recognition that a non-human animal, such as an elephant, who as we have demonstrated through unbelievable expert affidavits from 5 of the most renowned elephant expert cognitions, cognitive behavioral scientists, perhaps you would call them, who demonstrated that elephants are autonomous. They are extraordinarily cognitively complex. And these were attributes that Justice Tuitt focused on in the Bronx with respect to Happy, and also Judge Fahey spoke about with respect to chimpanzees. So what I find very interesting is that although Judge Fahey spoke about chimpanzees because it was a chimpanzee case, the language that he used was very broad in terms of chimpanzee cognition, chimpanzee intelligence, chimpanzee autonomy. And we're saying exactly the same thing about elephants. So if you read our brief, what we've done is when we talk about things that Judge Fahey said in his concurrence, while they were specific to chimpanzees, we say the same holds true for Happy. Because all of the things that Judge Fahey was saying in terms of how do we decide if this non-human animal should possess this right? In this case, we're asking the court to recognize the common law right to bodily liberty protected by habeas corpus, because once that is recognized by the court, Happy has to be set free, or the chimpanzee for whom we have brought petition would have to be set free. Because once that right is violated, once that right is recognized, the right has been violated by the imprisonment, and the whole recourse of habeas corpus is the immediate release of the prisoner. So basically, what we're able to do is use Judge Fahey's concurrence in our Happy brief, in addition to, and interestingly, Justice Tuitt, who heard Happy's case in the Bronx, also quoted Judge Fahey, because she too, and she said, regrettably, she could not rule in Happy's favor because of these lower court cases that she felt her hands were tied. But the beauty of now being before the Court of Appeals is that their hands are not tied. That's why we have, through all of our efforts, ultimately tried to get to where we are today, because we want to be in front of a court who, through their own lens, having nothing to bind them except their own precedent, if they, or even if they wish not to use their own precedent, they could deviate from that, but they are not bound by any lower court. So now we can go before them and argue, as we have been, that they must recognize under their own standards that they have set forth for a common law case, when they're looking to, as we're asking them to do, expand the common law, to recognize this right on behalf of Happy. All they need to do is now apply the same standards that they've always applied in this sort of a case, albeit it's never been on behalf of a non-human animal, but they have done it for human beings. And our argument is, once you do that, you basically have no choice but to recognize this right. So, Steve, I don't know if you'd like to add anything to that. We can also talk about the legislature, but, excuse me, if there was something that you would like to add before we move on.
No, I'm sure arguments will come in and out, but I mean, for example, we definitely chose the writ of habeas corpus, And one of the reasons why we've chosen it is that it's very important, and historically it's been really important if it seems like you're someone who doesn't have a right. And we cite cases, especially of a very famous case involving a human slave in England in 1772, using habeas corpus, and not just habeas corpus, but a common law writ of habeas corpus. And that's what we want. We want to use a common law writ of habeas corpus, because that means that that courts aren't going to have to look at statutes or constitutions. They're looking to see whether or not it's the right thing for them to do. And so that's one of the things that our brief is so much about, is really the right thing to do. And we try to argue why this is the right thing to do. Similarly, there might be something like the ideas of liberty or the ideas of equality. We argued that those are very important issues under habeas corpus, and you should be using them because New York believes that they're incredibly important things like equality and liberty. And then we argue in our brief why we use liberty and equality. I can talk about how we prepared the brief, which, if I can, I don't think I'll say too much about it, but it took us, I don't know, it took us hundreds of hours. Once someone is told that they're able to file a brief, which again was extraordinary because the Court of Appeals only takes 5% of those cases that go in front of it. So whenever they do that, that means once you learn that you're one of those people who can file a brief, you usually get, like we did, approximately 60 days. That's I think around it went from about May 6th or May 4th to July 6th. And in those 2 months, even an organization like the Non-Human Rights Project would end up spending enormous amounts of time. We spent hundreds and hundreds and hundreds of hours talking about what we're going to do, because this has never been done before. And it's it's not easy, because every other time in New York, the other 8 times or the other 7 times in which we have filed some kind of a case and made an argument, we were saying that the lower courts should do what the highest court requires it to do, and then we might have a fight about what that is. Now we're going up in front of the highest court and saying you should do the right thing. There are many legally correct things that you should do, and if it turns out that other things that you think have been the law that would go against us, you should change them, and you should change that part of the common law, and we would explain to them why. So many things we say that's what you're supposed to keep, but there are some things that we're saying, like, should a non-human animal ever have rights, that we want to change. And that's one of the only things that we want them to change. But we certainly want them to change that. So we would work individually, for many hours, and then we would go on Zoom like we are now, either from usually a 3 to 4 hour time when we've had 4 or 5 of the lawyers gather together on Zoom, for 4 or 5 hours straight, the first thing in the morning until afternoon. And then sometimes we did that once in a week, sometimes we did it twice in a week, sometimes we did it 3 times in a week, in which we would spend hours and hours and hours arguing how this should occur, what the Court of Appeals should do, because it really had never thought about it before, and we felt that we had a new explanation as to why the lower courts are wrong, but also why they're right. Liddy, do you have anything you want to add to that?
No, and
Okay.
It's amazing, when you are so entrenched in something, as we were in writing this brief, and that this is probably the most important thing that you will do in your career as a lawyer, and every single word matters. And you start after a while, maybe after the 500th hour, to start, I think, losing a little perspective. And it was very interesting because preparing for our seminar now, let me just read our preliminary statement in the brief, because we just filed it, but I almost forgot what we had said. And I'm reading it, and it's fabulous. And I was so happy because it said exactly if I'm the judge. And that's it, Steve and I do this. So we don't know the answer. And we take a step back and we say, okay, let's pretend we are the judge. How do we want this explained to us? What do we want to hear? And I'm reading it, and it went through very simply, but very artfully, exactly what we were going to be explaining to the court. And it was really good. And I was so happy. And, to Steve's point, we have spent years trying to convince lower courts that what they are saying is simply wrong. And we are now going to the Court of Appeals. Most of the time when you have the opportunity to go to the Court of Appeals, your issue is very narrow. And while our issue may appear to be narrow because it's a question, is the court going to recognize it's right? There is layer upon layer upon layer of bad decisions that have gone into us getting to this place, and us have to undo and explain all of these bad decisions. And the bottom line being how these bad decisions have basically created the precedent that in order to have a right, you have to be human. That a non-human animal cannot have a right because that non-human animal is not human. And Judge Fahey immediately recognized that as being wrong. We, of course, know that's wrong, but now we have to explain to the court why they always believe that to be wrong and what a person actually is. And being a person is not synonymous with being human. It is simply having this capacity to have a right, which we argue in our brief, many animals in the state of New York already do, because under the law in New York, you can create a valid and enforceable trust, and the recipient, your dog or cat or hamster or gerbil or goldfish, or perhaps an elephant in our case, because we did create a trust on behalf of Happy, as a recipient of that trust, has the rights of a trust beneficiary. That makes that non-human animal a person. So, we're not
Liddy.
deviating too far from what already exists. We're just asking
Sorry,
for different
Liddy.
rights.
Just
Oh,
sorry, Liddy.
okay.
I think you're breaking up a little bit. Steve, is that?
Yes,
having
yes,
that same-
indeed.
Oh, I'm so sorry. And it's not even, my phone isn't even moving. I'm so sorry. Steve, I'm going to let you continue.
It's okay. Actually, it's interesting in that we can spend hundreds and hundreds and hundreds of hours trying to figure out what the best arguments might be. But the court puts a limit of 14,000 words. So, which actually turns out to be exactly what it is. It's for us, we filed a brief that was 14,000 words. But if we didn't have that, we might have had 25,000 words or 30,000 words or 40,000 words. So on one hand, we're trying to figure out the best ideas. But on the other hand, once we do that, then we have to make sure that we can bring them all down to 14,000 words. So we had very many discussions and arguments about these two. One of these things is going to have to go. Should this go or should that go? And it would not be easy because we would actually think that we'd rather have both of them stay. So that's how we were preparing for the brief. And now on either May 4th or May 6th, sometimes I forget, talking about how you prepare for the hearing. So we've done the brief, the other side's going to file a brief, then we're going to file a response, and then we're going to have oral argument before all 7 members of that court. And so we spend an enormous amount of time trying to figure out, because you can't talk about 14,000 words. The most you're going to be able to get is 30 minutes. And you're trying to figure out what should we What should we talk about? What should we argue? What are the most important things? If we get asked something that we don't think is important, but some judge appears to think is important, then we have to be able to switch over to that. So it's the first time, just like there was the first brief, it's the first time there's that this kind of argument that a non-human animal should actually be a person. It'll be the first time that any of those 7 judges who will be there have ever heard anyone make that argument. So in something like this, anything can happen, but we've already been through 8 years of having anything happen. Every single case we filed all went in different ways, and we assume that this is going to happen as well. And when we were in Connecticut, actually almost the same thing happened. We were in front of 4 courts and they all went different ways. However, let's then talk just for a second about after we argue. It could be 1 month, it could be 4 months. We don't have any idea when the court will make its decision. If it turned out that we won, there's many ways in which you can win. There's many ways in which you can lose. So just because you win doesn't mean everything went the way you wanted. And just because you lose doesn't mean everything went the way you didn't want. So, but if the court recognized, for example, that the elephant Happy, who's been a prisoner at the Bronx Zoo for almost half a century, if Happy should have the common law right to bodily liberty, which means the court is going to say, we hereby order you as your right to come out of the Bronx Zoo, and then they would send her, we hope, to one of the best sanctuaries in the world, which are in the US. She would be all set. And then at that point, we would likely be starting to file lawsuits on behalf of every other elephant, who is in New York. If things went, if we lost, again, you can lose on many, many grounds. As I said, the ones that we lost in the intermediate appellate courts, we lost every time we went in front of one, we lost on a different ground. The 4 of them all ruled against us. But interesting, one of them didn't even rule against us because our chimpanzee client was a chimpanzee. They said they seemed to be kind of favorable to that, but found another reason, which turns out to be wrong. But that's the reason that they found. So if we lose, we would have to read it very carefully to see why we lost, to find out how we would then be able to continue to argue in our favor. We'll have to see what other kind of case we could bring, who we could bring on whose behalf, against who would we bring, what kind of intermediate appellate court would we go to, and then what our odds were, and they'd be 5%. But then, once we lost, if we did again, we would then try to get the court in New York, the Court of Appeals, to do the same thing. Can we be one of the 5% of the people who asked for you to hear our case, and then can we try again? So that's pretty much, I mean, we could probably talk for many hours, but that's when we're trying to talk, this time, you've got about as much as we could add in. So one thing I would like to do is to thank you for coming to listen, also for being a part of the integral part of this fight, which is a kind of fight that the Nonhuman Project puts up all the time, every day. Most of us work 7 days a week. Some work 6 days a week. Some, I guess, occasionally someone works five days a week. Because what we're doing is we're doing an enormous amount of work, and it's just not in New York. By the end of this year, we are almost certain to file another lawsuit in the state of California for the first time. Eventually, we're going to file. We're already working on a second lawsuit with another species. We're filing in California. We're going to have a lawsuit in Colorado that will also be filed sometime this year, probably the beginning of next year. We have a lawsuit that we've been already heavily planning in Israel, another one in India, and then we're beginning to work on one in Buenos Aires. So there's an enormous amount of work, because there, as you can imagine, they don't speak English in Buenos Aires. They don't speak English, in Israel, and the laws in India, or in Israel, or in Argentina, It's actually sometimes for us, even in California or in Colorado, can be extraordinarily complex. And so we have to try to figure out how we can come up with the same kind of strategies that we do when we filed those cases than we might in other cases. We also actually 2 years ago filed our own amicus curiae brief in the Constitutional Court of Columbia, trying to get a bear to be held to be, we were unsuccessful. Someone else brought the case. We just brought like a friend of the court, urging them to rule that the bear was a person with the right. Bear wouldn't be something that we would have filed a lawsuit on, because we don't think it's as clear as an elephant, say, or a chimpanzee. But we tried and we lost. But now we're working with Harvard Law School, and we sometime around November, the Non-Human Rights Project and Harvard Law School we will file another amicus brief, this time in the Constitutional Court of Ecuador. And there's two questions that both of us, Harvard and we, are trying to answer, which is number one, because the court asked us to answer these questions. Number one, why should a monkey, why should a primate, under what circumstances should they ever have a right? Should they ever be a person? So we have to argue why under Ecuadorian law they should do that. The second one, they noticed that they're the only country in the world who has a rights by nature part of their own constitutions. They want to know, should a monkey have a right by nature, pursuant to the Ecuador Constitution? So believe me, that's also will take us months and months to be able to fully understand. So again, thank you for doing this. And if you want to continue to work with us, please, we would be happy if you wanted to donate or continue to donate to the Non-Human Rights Project. It's a way we keep bringing in more lawyers, but and other people too, but everyone who works with us has only one reason, which is to have non-human animals in the United States or other places to be a change from the legal status of thing to the legal status of person, and then begin to get whatever rights we can get for them once they've been declared a person. And I think that's probably all you want us to say now, and then people want to ask questions.
Yeah, people have questions.
Super.
Yeah, so first one from Lady Nora asks, if we lose this case, since it's going to the highest court, where does it go from there?
I can answer it, or Liddy, are you on? Oh, I think you're still having problems. Okay, I'm sorry, say that one more time. I thought that,
I'm not sure, Steve. Can you hear me?
okay, I'll answer then. No, because you sound a little fuzzy there too.
Sorry,
Okay.
Lady. Yeah. So
Okay.
Say that one more time.
if we lose in this case, since we're at the highest court currently, where does the case go from there? Well,
we'd have to see why we lost. Did we lose for a reason that we could fix to win? Is it, would we see that indeed we lost? We think that the reason that we lost we can fix, and we then at that point we'd immediately file another lawsuit on behalf of Happy. So, or on the other hand, if they just said the reason you lost is forevermore and including now, the only time a non-human animal can never have a right, and at that point we would figure, well, we think we've lost the state of New York, that at least right now they're not going to allow non-human animals to have any kind of rights. We think that that the judges there are smart judges, understand history. They would not want to be viewed the way, for example, white judges throughout the 16th, 17th, 18th, 19th century would automatically treat all Black people terribly and rule against them. And now people view them horribly as the horrible judges they were. And the idea that a non-human animal could not ever get any kind of a right would one day you will be viewed in a similar terrible way. So that's why we're hoping that we do win. But if we don't, then we'll have to see what we can do, and then we'll do it.
Okay, thanks, Steve. So Joseph has a question. He asks, can supporting briefs from international organizations that have successfully argued for the rights of non-human animals be introduced?
That has never happened, with the one exception of India. I mean, it's never happened at the highest level, except under certain circumstance for animals in India. India is so unbelievable in that the Indian Supreme Court in 2014 unanimously said that all animals, every single one of them, would have rights under Indian statutes and under the Indian Constitution. We don't have anything like that, and I don't know of anything like that anywhere in the world. But that was for them 7 years ago. Other than that, either in Pakistan, in 2020, there was a judge who gave rights to a lot of animals. The most famous one is Kevin the elephant, in order to get them out of the zoo. But they were trial court. We have no idea what the appellate courts of Pakistan would do. Similarly, if you look at Argentina, at some of the lower courts have ruled in favor of chimpanzees or orangutans in Argentina, but they seem generally to get overturned by certain kinds of appellate courts. Although what happened for them is very complex, and when I read it, I'm not convinced that the people who say certain terrible things are that they're exactly that way. The same thing happened in Colombia. It lost, and then it won at one part of the Supreme Court. Then it lost at two parts of the Supreme Court, and then it lost on appeal to the Constitutional Court in Colombia. But it lost 7-2, and there's one tremendous dissent who I think will one day be adopted by Colombian judges. Let's see. Right now, we're doing the same thing in Ecuador. Let's see if I can think of any other places. So anyway, except for India. The Indian court, they using bullocks, they used Indian statutes and Indian Constitution to preserve the rights of a non-human animal. But there are no other high courts in the world that have done that. And so we're looking at certainly the second one who's done any part of it, and the first one of a lot of parts of it. But by the way, anybody can file an amicus brief. I mean, for either side. If you have tried and lost, or you haven't tried yet, I mean, anywhere in the world. You can be in Australia, you can be in Europe, you can be in South America, you can be in the United States, in Canada, anywhere in the world. You can file a motion giving your reason why you think Happy should have the right to bodily liberty, that would get her out of the Bronx Zoo and have her sent to a sanctuary. You may want to be qualified to do it, or else the judges won't pay any attention to you. But if you know really qualified organizations or really qualified people who could talk about and help instruct them as to why they should make that kind of ruling, certainly you can do it. And we frankly expect that there'll be a number of them. We've always had a number of them, but we tend to think that this is so important that it may be likely there'll be a lot more who usually come on our side.
Great. And I see Lyd is back, but
Excellent.
We'll see if she doesn't break up on us. I hope not. So
Fingers crossed.
Oh, you sound good.
Okay.
And so Anne asked this question, maybe Liddy, you can answer. So if we win this case, what are the implications?
Well, can you hear me? Am I fuzzy or good?
I can hear you, and you're good, at least
Great,
right now.
great. So the implications are interesting, and this is something that we actually have to deal with on multi levels, multifaceted, because on the one hand, this is a habeas corpus action, and a habeas corpus action is brought on behalf of one individual, and the remedy for a habeas corpus action is the freedom of that one individual. So, and one of the arguments that the Bronx Zoo is consistently making is that this could be a slippery slope, that if we were to prevail, that would mean that every single animal is going to be set free, and we won't be able to eat meat anymore, and all of these horrible things are going to happen and the skies are going to fall in and it's the end of the world as we know it. That is not what habeas corpus is all about. However, as I believe Steve mentioned, which is certainly accurate, when we win this case, what we will be able to then do, it will be precedential for other cases that may come before the New York Court of Appeals. And again, depending upon what the decision says, when we do win, we will have to see what it says. If we lose, we have to see based on what grounds. So depending upon what the decision says, we'll determine how the decision gets used, first and foremost on behalf of other elephants that we would want to file habeas corpus actions for. In the same way that we're talking about using Judge Fahey's concurrence about chimpanzees in our happy elephant case, we would probably want to use a favorable Court of Appeals elephant decision in other cases, in other habeas corpus actions, that because all of our habeas corpus actions, which is why we filed them on behalf of chimpanzees, elephants, and perhaps in the future cetaceans, we have it is evidence-based, and it's evidence-based on autonomy. So again, depending upon what this decision will say, we'll then determine if we can use it not only in New York, but in sister jurisdictions, because particularly in common law actions, the court very often looks to sister jurisdictions to see how they have ruled in similar situations. So I don't know, I hope that answers your question, but I think, that is how we would be able to use a favorable ruling in Happy's case.
Fantastic. Great. Okay. We'll move on to Janet, who asks, can you please talk a little about the doctrine of legal personhood for inanimate ships and corporations? And is this something that you reference in your briefs on behalf of sentient non-human animals?
You mean do we talk about what a person is? Oh, am I able to speak with them, or is it only everything in writing?
Oh, I believe she's asking if we talk about, rivers, ships, corporations.
Well, we briefly talk about it. Humans are persons, corporations are persons, ships are persons. I think sometimes we talk about different sorts of personhood, not many in the United States, but outside, for example, in the country of New Zealand, there's a river that has been named to a person. There's a national park who's a person. In India, before they were really doing it for all the animals, there was a Hindu idol. There were the pages of one of their Bibles, their religious group, they're literally their Bible. Now there was the Ganges River was said to be a person. Oh, I think that's on hold right now. I think one reason you'll see all these things is the thing about being a person is that means that you have the possibility of getting a right, and then that means something to someone. So if you have personhood, then what happens to you or your life, whether you're alive or not alive, or whether you're a tree or whether you're a corporation or whether you're a river or whether you're a lion, it would depend upon whether you are a person. Because if you are not a person, then you're a thing, which means you don't have the opportunity to be able to have any rights. And all those out there who do have rights can then do all kinds of things. Can do all kinds of things against you, which we do talk about that mostly with respect to what they do with elephants. But when we finish in a relatively small amount, probably a paragraph or 2 paragraphs, we would talk about other ways in which folks, especially outside the United States, have used personhood on entities who are not human.
Yeah,
And if I could
absolutely.
just add one other thing, Steve.
Oh, sure.
And again, I think it shows the evolution in our thinking over time, because when we first started, writing our briefs 8 years ago, 10 years ago, we thought that, well, of course, if a corporation, if a ship is a person, how could the court not understand that anything could essentially be a person, that it's not just limited to human beings? Unfortunately, the obvious is not so obvious oftentimes to a court. And, they've taken the position, well, a ship or corporation, they involve human beings. So, the personhood aspect actually deals with human beings as well. And now you're talking non-human animals, which have nothing whatsoever to do with human beings. So we kind of had to, while certainly the point is well taken that ships and corporations and particularly rivers, not in the United States, but outside of the United States, have been granted personhood. What we've tried to do is really just focus on what personhood is, that all it is the capacity for a right. It is not synonymous with human being. It does not have anything to do with the ability to bear duties, as 2 courts mistakenly decided it does. And that, as I said before, there are already non-human animals in New York, many, 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 who have rights, who have a statutory right. So we've kind of moved away from the corporate mentality into just addressing non-human animals.
I actually, that one thing was really interesting that Liddy was referring to. It's the pet trust statute in New York, and the pet trust statute is more than 20 years old. And what they simply said was that you could write a trust on behalf of a domestic or other sort of animal, and that animal would then be able to get the money from the trust, because you actually have a trustee. You have someone else who would help the non-human animal, who's an actual beneficiary of the trust. And so that means, since in New York, when you have all these, maybe millions of, I don't know, of non-human animals are actually beneficiaries of trusts, or could be beneficiaries of trusts. And as beneficiaries, that means that they are persons who, because once you have rights, and they have rights there, then you're a person. We argued that, I don't know how many, I'd have to think of how many courts we've been in front of. We've probably been in front of 15 courts, or maybe more. We always argue it. 14 of the judges ignore it. In other words, they don't even say that we argued it. One judge noted that we had argued it, but they only spent 1 paragraph on it, and didn't seem to really to truly understand it. It's extraordinary. That's something that we've actually put into all of our memos. We put into all of our briefs, and we argue it when we argue in front of the court. No matter that any of that happened, none of their decisions, except that one that was about 1 paragraph, ever explained or said why many non-human animals in New York already have rights. And we would argue Tommy, wait a minute, not Tommy,
Happy?
we would, oh,
We have a lot of clients.
No. Here's my problem. I can't. I had to put the trial up, the Leahy's case, Fahey's case, and what happened is that it talks about Tommy,
Right.
the chimpanzee. Anyway, so that's it, and it's we think it's hard to do. We never would have imagined that all these judges would be able to do that, to simply ignore the fact that they actually have rights, or at least try to explain why they don't have rights. But instead, with the one small exception, they never even say a word about it.
And we
hope
don't
that-
even, and to your point, Steve, the one small exception, what the judge was saying. So it's really fascinating that all of the judges have totally ignored it. And not only have they ignored it for, to say that, yeah, these non-human animals do have rights, but in our happy appellate case, one of the arguments that a judge made was, well, if you give one right, doesn't that mean that the non-human animal has all rights? Which is absolutely not the case, especially when you look at the pet trust statute. It granted one right to certain non-human animals, to pets, essentially, domestic animals. They have no other rights. To the best of my knowledge, my cat does not have the right to vote, even though I have a trust for her. So, it's something that we have always thought was so important. Other lawyers with whom who we speak to and explain this, they think that it's a game changer, and the judges just won't buy it.
That is true. If I remember the very first case we filed, eight years ago, there was a Harvard law professor. When we filed it, he read it and he wrote an article about it. He said, look, they have pet trust statute in New York. That should make it easy for them to get a right for their chimpanzee. And that professor was completely wrong. It has never been easy for us to do that.
So we have plenty more questions coming, but I did want to mention that we have hit the hour. So if there's anyone that does need to jump off, thank you so much for joining us. Anyone, everyone else who can stay, please feel free to. Steve and Liddy, are you okay to stay on for a little bit more? There's some of these questions.
I'll stay to 4 and Liddy can stay to 5.
Well, I have this sort of related question, interesting question from Sarah, who asks, is there the possibility of a third category somewhere between persons and thing that might feel less threatening to the judges?
Yes, there is a possibility, and it's just a pile of junk. It's a way of keeping animals from having rights. That's something that
you got me a little scared there, Steve, for a moment.
I did.
What? To tell you,
Say it
you got
again.
me a little scared when you said yes, there is a possibility. My heart sank until you said, but it's a pile of junk. Okay.
Yeah, we actually have a law review article that's kind of going to be coming out on this, and we're actually concerned all over the world that sometimes people are through statutes are trying to file something that doesn't give animals rights, and they claim it doesn't make them things. It may make them a sentient being, which we think is not a very good idea. It's not something that's going to help non-human animals. It's actually a way of going after non-human animals, it's another kind of welfare. And the reason why we're a civil rights organization is that we know from reading thousands of years of slavery, of reading thousands of years of how non-human animals have been treated, that the question, we don't care whether they aren't. I mean, if they're not things, that's not a big deal. If they're not persons, if they're neither persons, if they're not a person, but there's something else, it will not mean anything that we value. And so we do not want judges to ever do that. We do not want legislators to even do that. And anyone who thinks that it's really kind of close to rights, the next time someone wants to pass a statute that helps the animals, say, well, why are we using sentient beings? Why don't we use persons? And the answer will be 0. We're not going to do it. No, that's because sentient being is worth much more like a thing than it is like a person. So we're never involved in that sort of thing. Liddy, do you want to add anything to that?
No,
Okay.
no, that's, you took the words right out of my mouth. And, unfortunately, this is, a lot of the cases that don't deal with animal rights, but do deal with animal welfare, talk about, this kind of third category of neither person nor thing, but this third category. And basically what that is showing, in my opinion, is a lack of understanding of what a person is, a lack of understanding. Yes, I mean, you can improve the welfare of a non-human animal. You absolutely can. And I am committed to improving the welfare of non-human animals. But that's not, if you want to get a non-human animal out of prison, you're not doing it through a welfare statute. You're doing it through animal rights, and that being the recognition of bodily liberty.
Right.
And there is no third category to that. So, when you have decisions now that are coming down, which are wonderful, for example, in custody cases now, that you have to look at the best welfare, the well-being of the non-human animal. That's fabulous, and that's what they're doing is they're applying a standard that you would use for human beings, but that's not giving that non-human animal a right. That's just simply applying the standard that you should use when deciding where this non-human animal should be. And that's kind of like that third quasi category, which is not going to ever help an animal such as Happy get out of the Bronx Zoo.
Right. We support animal welfare. All of us have always supported our whole lives animal welfare as a way of trying to, when humans want to, then the non-human animals will do better. But they change their mind, then they'll do worse. It doesn't really matter. That's something that we've always supported. Anything that can help a non-human animal, even animal welfare, we've always strongly supported. But what we do not support is making non-human animals something that is not a person. If you're not a person, then you're not going to, then your true welfare is never going to be granted or allowed or done.
Yeah.
In fact, what we worry is that people who use some other thing, then sometimes you'll see people say, "Oh, look, now everything for the animals, this animal, other animals, everything's okay." And those of us in the Non-Human Rights Project knows this everything is not okay at all.
Mm-hmm. Definitely. Okay, so I'm combining a couple questions here, but so is the Bronx Zoo, to our knowledge, open to Happy being purchased and released in that way? And if Happy were to be released by the zoo by some way before our hearing, would the court still hear our case? What would happen there?
Well, let's see. The second part was, if that happened, generally, habeas corpus cases, once the problem doesn't exist anymore, generally those cases are dismissed. There have been some very small number of cases in New York, and none of them habeas corpus that I know of, in which a case like that has been has not been dismissed. So it would be overwhelming that would end the case. Of course, we've always, we are very concerned about our clients. We kind of become their lawyers, and from the beginning, we said, hey, if you do what you're doing, we're not going to file your lawsuit. If you do, or if you send the elephant to the to the various sanctuaries, we would dismiss it. If they did that, we would very much take that into consideration. I mean, we'd have to talk about it. We'd have to see what the requirements were. Also, no matter what we said to everybody, over almost 10 years, nobody has ever even responded to us. So we're not expecting to hear anything about that. What was the first part of the question? I think I forgot about it when I started talking about this part.
Oh, to our knowledge, would they be open to Happy being purchased?
Oh, you'll have to ask them. We have no idea. They don't talk to us. We wouldn't ask them. We have no idea under what circumstances they would sell Happy. We just, Liddy, do we have any idea at all? I don't think it's ever come up.
No, and I'm not. I'm a little bit confused by the question because, the notion of Happy being sold is, it kind of goes to this horribleness of non-human animals such as Happy being things that can be bought and sold.
Right.
And I'm not really sure, when you ask the question of could she be sold? I mean, could she be sold to a traveling circus? I mean, we are so particular in what we're doing, and that's why, for example, we haven't even brought habeas corpus actions on behalf of cetaceans yet, because we have to know that we have a true sanctuary where the non-human animal will be placed upon release. So, I would hate to think that, and this is something that actually scares me, that kind of like in the dead of night, Happy could be sold to another zoo. She could be sold as a roadside attraction. I just, so that is actually terrifying to me. The only place that she should go is one of the two sanctuaries in the United States. And if the Bronx Zoo was willing to do that, it would be a beautiful thing.
Yeah,
and it would have saved a lot of time, and it would have made Happy's life so good, because that's where she should be. And hopefully, when all is said and done with the Court of Appeals, that's where she will be.
If I may say, in one of the cases we did, I think 2014, 2015, we believed that the chimpanzee within the state of New York was about to be moved outside of New York, and we actually went in front of that appellate court and got an injunction against them being able to move the chimpanzee. And the only other court, actually, I forgot until right now, the Bronx Zoo twice would not say that they were going to move Happy out. We actually, during the trial, we actually got two injunctions against the Bronx Zoo that would not allow them to move Happy out of the zoo in the state of New York. And in fact, if we heard even a rumor about it, we would immediately go into the highest court and ask for an injunction, which I think we would get.
Right. Okay, so here's another question. What argument does the zoo use to justify continuing to keep Happy captive?
I think they own Happy, and they want her.
Right.
I'm not sure if it's any more complex than that.
Exactly. And I think, they have what we believe, as Steve said, to be the reason. They own her, they want her, she's a moneymaker. And then I believe they have the disingenuous argument that they make that she's happy where she is, that she's used to being where she is, that she has a good life where she is, and that she's well taken care of where she is. Unfortunately, and the reason I say it's disingenuous is because we provided the court with pages and pages, hundreds of pages from our experts disputing that fact. And they were not able to come up with one expert supporting that fact. So I think that bottom line, if they truly wanted to do what was, if they truly cared for Happy and they wanted to do what was right, they would have sent her already to one of these sanctuaries, one of these two sanctuaries. The fact that they're not just has to lead me to believe, as Steve said, that they're digging in their heels. They own her, they want her, and we should keep our noses out of their business.
You know, Lydia, I also think that that if they did that, other zoos who also would hate us as much as the Bronx Zoo does, would
Right,
get angry at the Bronx Zoo, because it'd be clear that we made them get rid of the non-human animal.
right,
And then
right,
they could say, oh my goodness, we're going to be seeing them. We're either going to hear about their influence, or we're actually going to see what happens when they sue us.
right, right. Which, you know, and it's so ridiculous because, and you know, this is something that we discuss in our brief, because one of the things we're asking the court in making their decision is to look at what's going on now in terms of what we know about elephants and where elephants should be. And this is why zoos are closing elephant exhibits. They know themselves that elephants cannot be held in captivity like this. And even the Bronx Zoo has admitted that they will be closing their exhibit. They're not taking new elephants because they know themselves that this is inappropriate. So it's very unfortunate, but mostly because of this is how Happy has to live, because they refuse to do it.
Exactly.
Right. We also had a few people, I know, Steve, you started to mention some of our work internationally and also in different states in the US, and some people just had a few questions about where and when. I know we talked about doing a whole Zoom on this conversation, and we'll do that soon. But maybe, Steve, you could give like a, I don't know if you can, like a very quick.
I'll give you what we don't usually talk exactly about what zoo or whatever or whoever we're suing, because we're worried, for example, that they may simply move the animal outside of the state and then we wouldn't be able to sue. And they might move them to one of the states in which we have no chance of winning at all. So I think what I can tell you is that we're about to file our first lawsuit in California, and that'll happen likely by October, perhaps more. We're also working on a second lawsuit in a different part of California. That will not happen this year. It's likely to happen next year. Then we're filing one again this fall in Colorado, and then we're bringing a lawsuit in Jerusalem, or actually in the Israeli Supreme Court, which is where it has to be brought, in Jerusalem. And then we're bringing another one in the High Court in Bangalore in India. And the purpose of it is to, we'd like to win, but if we lose, then we want to go up to the Indian Supreme Court and have them rule on some issues that we don't think that they may have completely covered yet. And then Argentina, we look at some of the cases that have been brought there, and some of them have very interesting things. And so we're talking about being able to bring a lawsuit there as well, because we think we may be able to get an appellate court to finally agree that a chimpanzee, is a person and has a fundamental right to bodily liberty.
Yeah, great. And we'll talk more about that in the coming months. And
Indeed.
yes. All righty. Okay. So I think we've gone over quite a bit of time. So I think we will leave it there. I think we were able to answer everyone's questions. If we missed your questions, I'm so sorry, but I'm going to put my email down here so you can feel free to email me. Thank you so much, everyone, for joining us and for following this progress in Happy's case and in our work. Liddy and Steve, thank you so much for joining us as well. Any last notes, any last messages?
No, I don't have any other than follow the case. And we filed our brief on July 6th. And the other side's filing theirs around either August 20th or 23rd, and we're filing ours like 2 or 3 weeks later, early September. So you can actually follow the arguments that we make. And of course, whenever the court finally decides when oral argument's going to be, we'll make sure everyone knows. And if it'll be in Albany, in the Court of Appeals in Albany, if you want to watch it in person, come and get a seat there, and probably get in early, because my guess is that there's going to be a lot of people who actually come to watch and listen, because whatever happens it's going to be the first time anyone's ever dealt with that in the United States.
Great. And Liddy?
Just thank you, everyone, for your continued support. It would be, I can't wait to be up in Albany. Hopefully, a lot of you will be there. We'll get to introduce ourselves to you, and it's really thrilling to be doing this work, to be part of the organization, to be working with Steve and with Mickey and all of the incredible, dedicated human beings who work tirelessly on behalf of our non-human animal beings. So thank you so much, and I apologize for technical difficulties.
Thank you. All right. Thank you, everyone. Thank you, Steve and Liddy.
Okay, you take care. Thank you all.
Thank you.
Bye.